All right. Hello, hello. Good morning, everyone. Thank you for coming. Thank you for joining our webinar today. So happy to have you here. We are going to be talking about nonprofit telemarketing, political calls. Let me introduce my guest today, Mr. Eric Troutman, also known as the Czar. He is an attorney. He has a law firm, Troutman and Men. He also has the platform TCPA World that delivers great content for everyone. It's very educational. And he is also the founder of REACH, Responsible Enterprises Against Consumer Harassment. Thank you, Eric. How are you?
Doing great. How are you doing? Always fun to be hanging out with you.
I am good. So I'm Tammy Glover Fowler. I am the Legal and Compliance Director for Contact Center Compliance. I'm sure you all are familiar with our company as well. So we have a platform that offers all types of compliance tools. You can use our software to do all of your DNC scrubs, your RNC scrub. We have a compliance guide that has everything you need to know about TCPA compliance at the federal level and state level. And we have a litigator scrub. So we're happy to help wherever we can. So let's do our disclaimer. This is not legal advice. We have Eric on here, but this is not legal advice. So if you need an attorney, you'll have to hire Eric on your own. All right. So Eric, let's just begin by talking about the kinds of organizations that we're referring to when we talk about nonprofit and political. So I think, most of us, we know someone that suffers from cancer, diabetes, all kinds of diseases that, we see loved ones suffer from, some even pass away from them. So we're talking about nonprofit organizations that have causes that are for humanity, that serve humanity, things like that. Political organizations, we need to know about what our candidates are running on, what our government is doing. These organizations go through the trouble of getting classified correctly, the correct tax filing status, 501c3 if you're nonprofit, 501c4 for social awareness organizations. You've got your 527, your PACs. So they've taken great care into setting up their organizations properly. They need to conduct fundraising. Research is necessary. And so they need to raise money for that. And this is a channel that is vital. This channel is never going to go away. It's always going to be a benefit. They're always going to need to use this channel for fundraising. Would you agree with that?
Well, I mean, look, I don't want you to jinx it because half the time I think the phones are going away because of how poorly the FCC is managing things with the 10DLC rollout and the mislabeling and the call blocking and all the chaos. I mean, it feels like people are moving to OTT services. So I don't want to jinx it because I'm a big fan of the public switch telephone network. I want it to last forever. But I do
Yeah.
wonder if, like UPS kicking out the mail system, if our phones are one day going to become obsolete. But the broader issue of, do folks need to be able to spread their message and raise awareness for issues and also, of course, do fundraising through the phones today? The answer is obviously yes. And it's a good news, bad news situation. The good news is that the TCPA at the federal level and the TSR at the federal level looks favorably on many of these organizations, and we'll talk about some specifics. The bad news is that in some states, at least in some circumstances, there is still some risk. And so it's not going to be as simple as, well, I'm a nonprofit, I'm making outbound calls to raise awareness for, blood cancer or whatever, fill in the blank. Or Reach, we're Reach, we're a nonprofit, we're a 501c3 organization, right? We are out here spreading the word to stop robocalls. It would be ironic if we chose to do this, but we can't just pick up the phone and start calling everybody and say, hey, you should join Reach. I don't know, maybe we should, but in any event, so it's not quite as simple as that, but it
Mhm.
is pretty good as we start going through this. Certainly a lot better than telemarketing calls. And, again, just not to let the cat too much out of the bag at the outset, fundraising calls are going to be a little bit more regulated than non-fundraising calls. But still, if you're a nonprofit, even your fundraising calls in most jurisdictions are not going to dream up or cause too much trouble. So happy to kind of dive into whatever you want to dive into, however you want to get to it, Tammy.
Yeah, yeah. And let's not forget about, the good old text messages. I
Mhm.
know I want to hear from fundraising organizations. Send me a text, let me make my donation. Um, so the types of things that they're doing is, membership renewals, lapsed donors, reminding them, hey, renew your membership, things like that. Monthly giving, donor giving. I just wanted to make sure I cover that so that people understand what type of fundraising calls are they making and why are they doing that. It's not likely that it's just a one-time gift. These organizations really try to develop a donor base, repeat donors, and the established business relationship is more prominent in this vertical, I believe. So,
Yeah. So let's just kind of talk through it at the federal level first, right? Federal level, you've got the TSR over here,
mm-hmm,
and you've got the TCPA. Right. Let's talk about the TSR first. Under the TSR, right, you've got to make sure you've got the right level of consent anytime you're doing a marketing call. Now, unlike the TCPA, which we're going to get to in many states, under the TSR, fundraising is marketing. I know that sounds weird, but even for charitable contributions, it is marketing, which means you have to follow the TSR rules. However, even though fundraising and charitable contributions are marketing, nonprofits are exempt from the TSR. So, what does that mean? It means if you are the Red Cross and you are calling as the Red Cross, even if it is to get you to make your monthly contribution or to sign up for a membership program or to make some, make some money payments, the TSR does not apply to you because you are a nonprofit. However, if the Red Cross goes off and hires Bob's call center or George's BPO to make calls on its behalf, guess what? They are bound by the TSR. So that's a fascinating thing to keep in mind, right? The nonprofit itself can make the phone calls, but the second they go to a for-profit enterprise that's making calls on their behalf, boom. Now they become essentially a telemarketer, and the TSR and all of the rules of the TSR now apply to them. Now, the rules are actually somewhat similar, right? I said there was differences, but somewhat similar in the TCPA context. Again, if you are a nonprofit and you are making outbound calls under the TCPA, it doesn't matter if they are fundraising or not. They're going to be treated the same way, which is good news, I think, for most people. So if you are, let's say you're working on Eric Troutman's campaign. Let's say that I throw my hat into the ring and I finally decide to get up there and try to clean up this poor country of ours. It's just kind of really not doing the best right now, but maybe we can turn that around, make it great again for real, though. We might be able to do that. So, assuming that Troutman was running and you wanted to be part of Troutman for Congress, outbound calls could be made on behalf of the nonprofit campaign. And that would be perfectly fine, even if the phone number is on the DNC list, provided that you are not using automated technology. So if my thousands of volunteers wanted to pick up the phone and call and say, hey, you should vote for this Troutman guy. He's really cool. He's got great facial hair. He wears cool hats and black t-shirts. This is the guy for you. You could definitely do that. Even if that phone number is on the DNC, even if at the end they're like, hey, and you should give him 25 bucks. that is all okay, so long as the phone is being picked up. And same thing with the text message, right? So long as there's a volunteer bank somewhere and somebody's like clicking that button, right? And we're going to talk about what that means here in a second. But let's assume that there's a real life person and they're sending out a text. Make it the easiest example. Real life person sending a text, hey, you should give $25 to the Troutman campaign, and hit send. Even if that consumer is on the DNC list, that is okay. You are allowed to send that message because that is going to be a nonprofit organization. And even if that you don't have any form of consent at all, you are allowed to send that message. That is also true if you are using pre-recorded calls, but only to landlines. If you are using a pre-recorded call, an ATDS, any form of regulated technology to a cell phone, it doesn't matter that you are engaging in core political speech. First Amendment doesn't matter. Thou shalt not use regulated technology. Doesn't matter who you are. Doesn't matter if you're a nonprofit. Doesn't matter if you are a profit. It doesn't matter who you are. You cannot use regulated technology to contact a cell phone, period, full stop. Excuse me. Over in the landline context, though, different rule. In the landline context, if you are communicating with a landline, you can, even without consent, either for fundraising or non-fundraising purposes, as long as you are a nonprofit, send up to 3 messages per month, completely free of any form of consent to those landlines. So if you want to, again, you want to collect for Troutman, now we're going to, throw you on the old AI robocall machine, right? And you're going to call that landline and attempt to talk to that consumer to convince them to vote for me or to give me some money. You are allowed to do that up to 3 times per month. Remember, there are some disclosure requirements. You have to disclose who you are. There's also a automated do not call prompt requirement that is required on those voicemails as well. So up to 3 per month, you have to comply with those other rules, but you can send those even without consent. And of course, if you do have consent, express consent, right? They've asked to be communicated with, then you can also use that additional level of communication to those landline numbers. So that is your lay of the land at the federal level. Fairly straightforward. A couple little traps. I know once in a while people get in trouble because they think, oh, I'm a candidate for office. I can use those robocalls, right? I can record my voice. Hey, this is Eric Troutman, your favorite candidate for Congress. You should vote for me because I've got a great hat and t-shirt and facial hair. But you can't do that. You want to do that. You feel like that's an effective way, and people do it. It's illegal, but people still do it, and they get sued for it all the time. All right, so let me pause. That is like the high level review at the federal level.
Right, right. No, thank you so much for that, Eric. What about if we get prior express written consent, then we can send that pre-recorded call to a cell phone for solicitation. And if it's informational only, we just need prior express consent to send a message, pre-recorded message. So I would add that.
Yes.
Yeah.
So yeah, if you've got the right level of consent, then you can leverage that regulated technology, right? Express written consent will allow you to engage in any form of fundraising. Express consent will allow you to engage in any form of informational messaging. I will say, and again, using that regulated technology, now we're talking about the AI and the pre-records. I will say, in the political space and maybe in the nonprofit space too, people love to sell these lists. They love to sell these donor lists. I remember, who's that lady? Katie Porter. She was my Congress lady here before. Now Min is the congressperson. Very, very, in my opinion, not a very strong candidate. That's why I'm thinking I might run. It should be very easy if I do. But Katie Porter was pretty strong. And I remember laughing because she had a very good donor list, and she actually sold her donor list to raise money for her senatorial campaign, which ended up being a dud. But I just thought it was so funny. And she sold it for like 85 cents a name. And they had like hundreds of thousands of names on there, right? So you give money to Katie Porter because you like Katie Porter, or to whoever your candidate is, right? Of course, I would never do this to people because I'm not a sellout punk. And then they turn around and they take your list and they sell it. right? And now I know I've got a lot of people on here. They're like, well, time out. I'm a platform. I like it when people sell their list 'cause that's more phone calls for me. Respect, whatever, love. But if you're a consumer and I give money to one person, that doesn't mean I want to hear from somebody else. If I give money to one charity, that doesn't mean I want to hear from a different charity, even if it might be similarly related. So you got to be careful, right? Because if you are buying a list, maybe Katie Porter had consent, express consent, right? Maybe Katie Porter could have used pre-recorded calls, but just because the consumer is on a list that you buy does not mean that you have express consent, right? You got to be really careful with that, especially in
Mm-hmm.
political, right? Because the scope of consent and some of these, I mean, who's the big one? It's like, what is it, Act Blue and Think Red or whatever it is. Like there's the big engines for both sides, and they will generate consents, and they're very vague. And it's like, what does this apply to? What does this not apply to? And then you've got the stops, right? And that's something you've got to keep in mind we haven't talked about yet, is however you're framing out your consents, right? You got to make sure they apply to you. Got to make sure that you've got the right level of consent for the technology that you want to deploy. And again, as I already told you, you can buy a list in cold call as long as you're doing it manually. You can.
Mm-hmm.
That's allowed as long as you're doing it
Right.
manually and you're a nonprofit, right? But as soon as you lose using that regulated technology, you got to be very, very, very careful. And then that bleeds into the stops, right? If somebody is giving you a request to stop calling, you've got to honor that, especially
Right.
if you're using regulated technology. But even if you're not, right, you still need to be cognizant and honoring those do not call requests so you don't get yourself in trouble.
Right. Right. And I don't think that's the best way to go about fundraising in this vertical, is to sell those lists, because like I said, you're trying to get repeat donors. Like if you run for Congress, you're gonna go after a donor base, and you're gonna want to keep those donors for yourself. Um, can we talk about, I I love the history of how the National Do Not Call list became exempt. I feel like if Reach were around back then, this is something that you would have defended, because we had industry trade groups, speaking on the Senate floor about, okay, this National Do Not Call list, you cannot include nonprofit and political fundraising, because this is a violation of free speech. And also you have to exempt the EBR from this, federal do not call list. I think it's fascinating how when we come together as an industry, we can make a difference. And I think had the trade groups not been involved in that, we wouldn't have been able to protect, this exemption for nonprofit and political. Don't you feel like Reach would have been there?
Oh, of course. Oh, of course. I mean, look, Reach is the most active, the number one most active trade organization in this entire space right now. Nobody does more advocacy than Reach does. And, no surprise, I've got my political leanings, so it all kind of bleeds together. But I mean, it's worth just kind of reflecting momentarily. I don't want to sidetrack us too much on history, but
Yeah.
remember, the First Amendment says that Congress shall make no law abridging the freedom of speech, period, full stop. That's what it says. And yet Congress has made many laws abridging the freedom of speech, which begs the question as to how that can be. Now, the Supreme Court has dreamt up a bunch of reasons and nuances as to when it's okay and when it's not okay. But one of the big ones, and this was a really important ruling that came out a while ago. It was called the City Struthers. Was it? No, Martin versus City of Struthers. It's one of my all-time favorite Supreme Court cases. And it's the case, those of you who went to law school, I'm sure you studied it. Those that you didn't, maybe you've heard of it. It was the case of a town that had an ordinance that said you cannot do solicitations. The whole town, you're not allowed to knock on someone's door and talk to them about, you should convert to become a Mormon, or you should buy my tin cans. The thinking was that, the people would be bothered. It was a nuisance. And so we're just going to ban it. We're just going to ban the entire practice. The Supreme Court said, no, you can't do that. You can't impose a blanket restriction on presumptively constitutional speech, right? This is America, and whether people want to hear it or not, you're allowed to talk to them, right? That was the holding of Martin versus City of Struthers. Now, there was a exception recognized at that time, which is that if you put a do not solicit sign on your door, you, as the owner of the house, can decide who gets to come talk to you on your property. That's fair and reasonable. And so when Congress drafted the TCPA in 1991, it was looking back at City of Struthers and it said, okay, well, we can't ban all telemarketing calls. That would be a violation of the Supreme Court's ruling. But what we can do is empower essentially a nationwide do not solicit sign on our cell phones. And that's what the DNC was designed to be. And, truthfully, I support it. It's consistent with the Constitution, it's consistent with the Supreme Court. So I had no problem with the idea of creating a de facto sign, right, that you, if you want, can put on your phone and tell people that they can't solicit you. The other piece, though, of the TCPA, excuse me, is the regulated technology piece. And this piece I've always disagreed with because the regulated technology piece is not an opt-out, right? It automatically says if you're using certain technologies that you're not allowed to call someone's phone. And so to me, that's always been one of these restrictions that prevents core speech, right? Constitutionally protected speech without the consumer first saying, I don't want to hear it. So for instance, if there was two DNC lists, right, and one said no telemarketing and one said no regulated technology, that's fine. But instead, Congress just imposes that non-regulated technology requirement on all of us, right, without our permission, and in so doing, prevents people from speaking in a way that the First Amendment would protect. So I don't like that regulated technology provision, but the DNC provision I agree with. But you're not wrong, because back when the DNC list came to be, there's a big history of this. There was a book called Telephone Terrorism, written by a guy, I think his name is Dan Brown, which is not the same Dan Brown that wrote the other books. But he's got a really good history in that book, and I read it. It's a really good book. And he talks about how people were very scared, the telemarketing industry was very afraid when this DNC list came in, that they would just basically be shut down because at that time, people were doing a lot of cold calling, right? Now, the fear and trepidation of, the shutdown of an entire industry really was overblown. And to a large degree, it's because the internet came along right around that time, and there was different channels of communication, different ways to communicate with people, including email. And then more recently, of course, the lead generation industry and world has kind of stepped in to start bridging those gaps. But tying it back, of course, to the topic of our conversation, which is nonprofit and political, those messages were viewed, again, as, core political speech, nonprofits, the lifeblood to charity. That, what you started with at the very beginning of this webinar was the pitch that was made, of course, to Congress, and that led to the carve-outs that we see. And they're very, they're very good carve-outs, in terms of the extensiveness of the carve-out. Many times today, if you see a carve-out, it's going to be carve-outs with, exemptions to exemptions to exemptions to exemptions. That's not the case with the TCPA. I mean, if you are a nonprofit, you are exempt. That's good. I mean, that's really nice.
Yes, thank you for indulging me on that. It's just fascinating to me, what a trade organization can do and how that was carved out. I just think it was really important. I was actually around and worked for a company who was sending representatives to the Senate to speak on behalf. So thank you for that.
Oh, sure. Well, hey, thank you. You were around back then. I wasn't. I don't know what the heck I was doing in 1991. I think I was in junior high or something. I don't know.
Okay, so you had touched on disclosures, pre-recorded. You touched on that already. Let's let our audience know, when you're conducting these types of calls, there's a registration requirement. You have to register as a nonprofit with the state and let them know you're going to be soliciting to consumers in their state. If you use a third-party fundraiser, you're going to have to provide them with a report at the end of the campaign, let them know how much money you raised, how much you kept, what portion went for administrative purposes, how much actually went to the charity. So there's a lot that goes into nonprofit fundraising, a lot of tracking on what you're doing, a lot of accountability.
Yeah, so at the state level, we're just talking about the federal level, right? At the
Hmm.
state level, there's all kinds of stuff, guys. There's a huge
Oh
thicket.
yeah.
And I look, as an attorney, I'm not even qualified to tell you everything you have to do, right? I'm here to tell you what the rules are for outreach, period, full stop, right? I can tell
Yeah.
you when you can make a phone call, what your phone call can say, what it can't say, what it has to say, how you can make it. But to your point, there's a whole nother level of regulation and reporting requirements that you need to be aware of. And that's true really in every industry and every vertical, right? Where we come in, of course, as outside counsel at Troutman and Mean is making sure that you know if your outreach is legal or not. Beyond that, you're kind of on your own. You're not on your own. You have other lawyers. But at the state level, it's a good pivot. We have to keep in mind that the rules are fairly similar to the federal level from a structural standpoint, but of course the little sub requirements are going to be different. And I want to call out Utah, right? Utah in particular is causing a lot of trouble for people because unlike the federal level in Utah, if you are fundraising, even if you are a nonprofit, you have to have consent to make a call. Even if you're calling
Mhm.
manually as a nonprofit, if you are fundraising in Utah, you have to have consent. And that just caught was it the National Republican Senatorial Committee, NRSC? They're potentially in some trouble because there was a stop request case out there in Utah, and they weren't honoring stops. I mean, probably they felt like they didn't have to, and they are facing a pretty big suit from the Law HQ guys. Now we'll see what happens.
Mhm.
Maybe they settle it out or something. But Law HQ doesn't mess around. They're pretty aggressive. They're pretty mean. So we'll have to just kind of see where that one goes. But Utah is
Mhm.
a state that needs to be called out, um, and it's just one to keep in mind. But in most states, right, the rules are going to more or less track the federal level, and by that I mean if you are calling manually as a nonprofit, you're probably going to be okay. Okay. If, however, you're using regulated technology, and that's where the differences are, right? Some of these states have, like Oklahoma, Maryland, they have broader definitions of what an auto dialer is. Texas, my goodness, Texas, their new auto dialer definition, if you're using any kind of technology that has the ability to leave a pre-recorded message, even if you're not using it, that's probably an auto dialer in Texas. And that means you're going to have consent in order to use that system, even if you're a nonprofit, right? So that is a big deal.
Mhm.
Texas is a big
Yeah.
one. This is new. And this goes into effect, it's not in effect, as we're talking, it's August 25th. It's not in effect today. So if you're making calls in Texas right now, don't let your blood go cold because you're still okay today. But come September 1st, that's like a week from today. Good timing. A week from today, that's going to be in effect, and you're going to have consent now to leverage any form of automation in Texas. So,
Yeah.
and that includes click to dial. I mean, people are like, oh, I click to dial, P2P, P2P, P2P. Don't matter. It doesn't matter. You can P2P until your fingers fall off in Texas. If your system has the ability to leave pre-recorded calls, that is an automated message that you just sent. So you got to keep that in mind. And
Yeah. The
there's
states.
kind of risks like that are popping up everywhere. In fact, before I forget it, because we've already kind of run over this, let me come back to it, and then we'll finish up on the state law as well.
Okay.
Remember, SMS versus MMS, right? SMS is just texting. The rules on texting is pretty straightforward. If you're using an automated system, again, at the state level in Texas, you might be using an automated system. At the federal level, of course, it's that big ATDS analysis that you have to do. Remember, whether or not you're using a random or sequential number generator to either
Mhm.
or
Mhm.
to store the phone number, right? And if you're storing phone numbers, that includes sequencing using the ROS&G. So it's not as simple as, well, I'm buying a list. I'm not randomly creating phone numbers. Doesn't matter. Also, you guys know, hopefully clicking a button doesn't matter. I mean, if you are, great, but it doesn't mean you're not using an auto dialer. If your system has that capacity at the federal level, at the state level, you're still using an auto dialer, even if it's P2P, even if you're clicking. Hopefully you guys know that. But the point that I'm driving at, we can unpack that more if people will need. The point that I'm driving at, though, is what it means to be using a pre-recorded voice to deliver a message, right? A pre-recorded voice call. And that issue arises with MMS, where people want to send video messages, right?
Oh my.
Right?
Right.
I'm Eric Troutman, vote for me, right? And then, I send that
Oops.
little movie file or where the hell it is to my
Nope.
bank of volunteers, and they're sending those out, sending those out, sending those out. Well, guess what? Now you're
Guess
using a
what?
pre-recorded voice, right? That is maybe a pre-recorded voice call that automatically triggers a TCPA, even if it's sent manually. Now, there's one case so
Mhm.
far out there on this, and it comes out the other way, which is good, right? It says, no, 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 no. As long as it doesn't automatically play on the person's phone, then it's still just a text message. Great. It's good to have that data point, but I want to tell you, I don't think that's right. And the Ninth Circuit Court of Appeal in dicta, that means in a non-binding fashion, has suggested that an MMS message that contains an audio file or a video file that has audio would constitute a pre-recorded voice message.
Mhm.
So again, be very, very careful. Those of you that are in the political game or the nonprofit game, right? I know video can be very, very powerful. And you want to mix video with an audio element. I get it. I would highly suggest, not legal advice because I'm not your lawyer, unless I am your lawyer, in which case, fine, sure, legal advice. You do not want to include audio in any either video or MMS format communication that you're having without consent. Obviously, if you have consent, the right level of consent, cool, no problem, fire away.
Mhm.
But if you want to communicate in a non-consented basis as a nonprofit, got to be careful with those
Mhm.
MMS messages.
No, I'm glad you inserted that. Definitely. So going back to the states, I'm glad you brought that up as well. So, you know how you said from an attorney's perspective, you can let people know, whether your calls are legal or not. From my position with our platform, people come to us for the state regulations. Our compliance guide breaks down federal rules, state regulations, nonprofit, commercial. I remember doing this back in the day manually, tracking all of this. So to have it on a platform in one place, trust me, it's a good thing. So yeah. Um, can we talk about caller ID, which is the same across the board? I think this is a good place to insert your Dabrowski case that you wrote about. Because caller ID, whether
Interesting.
you're nonprofit, whether you're commercial, no matter what you're doing, you're supposed to provide the telephone number and the name of the organization for your campaign.
Well, it's interesting that you raise this. Actually, maybe I should have looked at that question before I jumped on this webinar because you're right. It applies regardless of whether or not you're a nonprofit, but it only applies to telemarketing calls. And I'm trying to remember if the telemarketing definition tracks the TSR definition or the CFR definition. I think it tracks the CFR definition though. And if it does, then fundraising is not going to be included. Only buying, selling, or renting is going to be not sorry, either investing, buying, or renting is going to be included in the definition. So that's an interesting one to keep in mind. But kind of backing up, let's just state the law and then we can get into the nuances. Um, if you are making an outbound call for telemarketing purposes, and we have to kind of figure out what telemarketing
Mm-hmm.
means here, but if you're making a call for telemarketing purposes, you must display on your screen the name either of you as a telemarketer or of the brand on whose behalf the call is being attempted. If you do not, it's an automatic violation of the CFR. It's an automatic $500 violation. There is case law now suggesting, and this drives me crazy, that this rule applies even to SMS messages, which I'm not exactly sure how it's even possible to pass along in the 10DLC context, the name of the sender in a text message, right? I'm not talking about the content. Obviously, you can put
You're talking
this
about
is
caller
there in the
ID.
content.
Yeah.
I mean the caller ID, right? Now, I know that there are new, rich text, RCS, whatever they call that, and you can do branded text in that format, like on Apple. But more broadly, just on a straight SMS protocol, I'm not even sure you can do it, but there's case law suggesting that you have to.
Mhm.
I don't know about that. All of this terrible case law brought to you by Big Law, by the way. This guy Dombrowski, who's just like a little individual troll, is out there just cracking, guys that are charging God knows what at big law firms. And he's won these cases now. There's like four of them now. And so unfortunately,
Yeah.
this is the law. But again, for the people listening here who are nonprofits and political, we gotta, I don't have off the top of my head the
Yeah.
definition of telemarketing in that specific provision, but I do want to say, Tammy, that I think it is not going to apply to nonprofit fundraising and political fundraising. Um, but you should just take a note of that. But for those of
Yeah.
you that do multiple things, multiple verticals, and do marketing, keep this one in mind. Big deal.
Yeah. And I didn't put it on the list. I thought about it afterwards when I was thinking, caller ID, this is perfect because I actually do think it tracks. So we'll just take that one off, but I think it tracks. Just having worked in this vertical in the past, we always made sure, or maybe it was best business practices. Like don't do that. Even if it doesn't track, don't send your calls out without the name of the organization and your telephone number. Always provide that to your carrier as a best practice. So looking at the back end of that, since there's a private right of action there, but we still got to look at the carriers, making sure that they deliver that information as well. So I think that's going to be the big thing. Like even though with the case you wrote about, even though there's a private right of action with it now, if you do your due diligence and make sure you provide the phone number, the name, the carriers will be looked at too because you're supposed to deliver that information. So I think there's going to be more than one person at fault here if we find that someone wasn't doing that.
Going to be an issue.
So
Hey, before we move to the next topic, I was just reviewing some of the questions. Dave Frankel, um, famous in TCPA world circles, reminds me to remind all of you that the nonprofit rules actually apply to tax exempt nonprofits. So just because you have organized yourself as a nonprofit, under state rules, let's say, you do have to
yeah,
have that tax exemption before you are allowed to leverage the DNC exemption. And so that was a really good point, David,
yeah,
for having me highlight that.
yeah, that's true. Yeah, they go through that trouble when they're setting up their organization. That's
And
why
it
in
takes a
some,
while. It took Reach like a year
yeah,
and a half to get the 501(c)(3) finally back from the IRS. Um, that was a real pain. So, but we're all set
yeah.
now.
Okay. The call to action, we wanted to get into that. I'm gonna throw another one of your cases in here.
Okay.
The Germain v. Mario air conditioning is just the perfect example of how a call to action can change the complete intent of your call. This was the one about it was supposed to be an
Oh yeah.
informational text and it wasn't. Like if
Well,
you,
so that case pisses me off because, and again, I'm trying to, those of you that follow TCPA world closely, you know that I take the TCPA very, very seriously, maybe too seriously. I don't know. And I hate it when, other firms screw stuff up, low-hanging fruit arguments, they get beat, they create bad case law, and then my clients have to deal with the bad case law. And so I became very, very grumpy for a while. And so I decided, you know what? Like I've got this like old man yells at cloud vibe recently, and I'm like, no, we're gonna turn it down. We're gonna calm down and be nicer, right? So I've got this new, nicer vibe that I'm going for. But the one that really set me over the edge was this Germain case. Like I literally was like screaming at myself in the office. I was so pissed off at this firm that had how bad of a job they did defending this case. Just from a procedural standpoint, they lost summary judgment on the key substantive issue to the plaintiff. The plaintiff won summary judgment on the key issue before certification, which should never happen. There's a doctrine called one-way intervention that prevents a defendant from having to suffer losing something substantively before the class can opt in, which of course the class members now had there'd be no reason for them to opt out. They just won the biggest issue in the case already before certification. It was procedurally, it like makes my blood boil how bad the attorneys were. I'm sorry. I hate to be so mean. So anyway, I wrote this scathing blog and actually took it down because I was like, you know what? This is just plain mean. But setting aside the procedure, the substantive issue was a complete screw up as well. Because getting to it, right, what the text message said was, because there's a hurricane coming, Category 5 hurricane coming down, right? So Mario's AC, which is a local little AC company, sends out a blast to everybody in the hurricane saying, hey, turn off the fuse on your I forget what the exact wording was, but it's basically like be sure to turn off the circuit to your AC so that it doesn't get damaged, because if there's like a surge, I don't know how it works exactly, but apparently there's a surge, and if you don't turn off the circuit breaker, the parts of your AC can get destroyed. And then it's like in the middle of summer, right? So once the hurricane goes through, if your AC gets destroyed, well, guess what? Now you don't have any air conditioning in a hot, humid summer when there's presumably destruction all around you. So this is like a life and death potentially situation. It's an emergency message as far as I'm concerned. But what they included at the end was basically like, we're here to help at the end, right? So the defense moves for summary judgment and the plaintiff moves for summary judgment, arguing that, the line, be sure to, whatever, take care of your air conditioner so that it doesn't get destroyed, and we're here to help. Is that marketing or not? To me, this is an emergency purpose message, so it's not going to be treated as marketing, or it shouldn't be treated as marketing. But the plaintiff successfully convinced the judge and won the issue because, again, in my opinion, bad briefing and bad lawyering, that did constitute marketing simply because of the phrase, we're here to help. Now, that's just a bad ruling, in my opinion, again, enabled by bad lawyering. But ultimately, it does drive home the point that the content of the message, which, by the way, is irrelevant because whether or not something is marketing turns on context, turns on the substantive, subjective mindset of the sender. Am I intending to market? Is the actual standard. For some reason, this court applied an objective content-based standard, which should never have applied. Leave that alone. The point is, your call to action, the content of your message, whether it should matter or not under the actual prevailing legal standard, will sometimes lead to an interesting conclusion by a court. So you've got to be thoughtful in terms of how you're crafting your messages. Now, again, in the context of this webinar, where the folks are presumably exempt, at least at the federal level, it really shouldn't matter, right? You should be able to craft these things however you want, so long as your call to action is tied back to helping the Red Cross, right? Or tied back to helping, whatever it is that is your nonprofit organization. Obviously, if I'm Reach and I'm sending a message on behalf of Reach and I slip in and hire Troutman Amin, okay, you can't do that, obviously. But hopefully you all are smart enough, like, you can't do that and you wouldn't do that. But yeah, so we need to be cautious around the contents of our messages in some contexts, for sure.
Because that call to action will change things for you. So if I'm a nonprofit organization and I have expressed consent and I want to send an informational message, well, I got to make sure that content is informational, but if there's anything in there that implies or sounds like a call to action, I need to make sure that's not in there. And also, if there's something in there that says, go sign up here to do the walk for hunger or whatever, and then you find out that the ultimate objective of that campaign is to fundraise, well, now the call to action has changed from informational to actually soliciting a donation. So just to go a little more on that call to action can completely change the intent of your call. And like you said, it's what is the overall objective of my campaign? Is it strictly to fundraise or is it strictly informational? And so that's we need to be careful. I just want everyone out there to know that be careful with the language of your calls, your pre-recorded calls, and make sure that it sticks to what it is that you're actually trying to accomplish.
Perfection.
So,
What
all
else you
right.
got for these good people, Tammy?
So let's just do practical guidance. I'm looking at the clock here, and then Sativa, our marketing manager, is on the line. I'm not sure if she's captured questions, but while she looks for that, practical guidelines is definitely hire legal counsel, right? Compliance professional, have that in place. Policies and procedures are always, they're necessary. I wouldn't say good to have, I would say necessary. Do some internal audits and some risk assessments on your campaigns, on your activity, just to make sure that you're doing everything compliant. So that there's no fault in the end, and self-regulate, become a member of Reach. Reach has standards. This is the only trade in industry organization that we have. So lean in. Um, do you have anything to add at the end here as we see if we have any questions, Eric?
Yeah, I mean, and just in terms of, practical takeaways, I think it's just important for folks. And again, most of the people that are listening to this are very sophisticated, but let's assume this shows up on my YouTube channel and, folks are kind of getting into the industry and are trying to learn about it, right? Understand kind of where you fall in the assessment of risk, right? Are you doing cold call solicitations for fundraising, relying on a nonprofit exemption? Are you a for-profit enterprise that's just doing some calls on behalf of a nonprofit, right? Are you going to be focused on a specific state, doing specific nonprofit-y sorts of things? Are you in Utah, right? Like, understand where your risks might be. Are you buying data sets, or are your data sets curated in some way? If you're buying data sets, are you treating those as consented? If so, you got to be very, very careful. If you're not treating them as consented, less careful, but still watch out for D&C issues, right? So there's just like, you want to just make sure that you're identifying, right, issue spotting. Are you using MMS messages? Are there voices involved? Are you going to use AI, right? Like, just really think about the kind of technology you're using, who you're reaching out to, where you fall in the pecking order of organizations as a nonprofit or as a for-profit, and ultimately, right, and like most importantly, are you tracking that level of consent that you need, or are you relying on exemptions and operating without consent, right? If you can kind of identify this, make sure you know where you fit, like take out a pen, take out a piece of paper, like map it out and explain to yourself, right, why this specific campaign, this specific call or text campaign you're going to do is legal because I'm exempt, it's not a regulated technology, or it's consented, whatever it is. Like, make sure that you can say it to yourself, because you might be saying it to a judge or a jury one day. And
Yes.
if you can't do it, I don't blame you, because some of the stuff is pretty complex. Again, mercifully, this specific area is less complex than other areas of the TCPA. I don't want to say it's easy. I don't think that's right, but it is less complex. So you might be able to navigate it for yourself, again, with a cocktail napkin and a pen, if you really just kind of think it through and just make sure you're checking boxes. But you still probably want to get yourself an attorney, right? Compliance professional, somebody to kind of look over your shoulder and make sure you're doing it right.
Mm-hmm. Thank you, Eric. I do see some questions here. You talked about Texas. We'll skip over that one for now. What about the case where nonprofit outsources the calls to an AI assistant? This is going to be our pre-recorded call
Yeah,
situation.
yeah. AI is going to be treated as a pre-recorded call. Okay, so that now you've got regulated technology, and now there at the federal level, you're not exempt anymore, right? If you're contacting a cell phone using AI technology, you're not exempt. If you're contacting a landline, leaving that voicemail, you've got 3 calls, right, per per month, you got to make sure that they're leaving that do not call and identifying themselves. So you got to be very, very careful with AI. AI is fun. It's a lot of fun, but you got to have the right level of consent in order to use that AI.
And disclosures. Yep. If federal law allows political calls or texts, but a state law bans it, which rules should I follow?
You got to follow both. Now, and Pooja put this in there. There are a couple of states where a state law like Montana had prevented political messaging, and they were actually struck down as unconstitutional. So there might be a challenge that you can come up with, but that be careful because it's one of these, a constitutional argument is kind of like the paddles when you're in the hospital. Like you kind of have to die first and they'll bring you back to life. Like I never want to be like, oh, well, I lose, but the Constitution says you can't kill me. So, just keep that in mind, but you have to follow both sets of laws at all times, in all places, right? If there's a federal law and a state law applying to anything that you do in life, you got to comply with both. Even if one is more restrictive and one is less restrictive, you have to comply with the more restrictive rule. Even if they somewhat conflict, you have to find a way to comply with both of them, right? This is the beauty of living in America, where there's states and federal, and you have to comply with both laws.
Is the czar going to create a mini TCPA end of the year review for 2026?
I hadn't planned on it. And if we do, it won't be the czar doing it because you guys know, right? Eric Troutman operates at the federal level, but Pooja and Angelica, in particular, and also Tom and more recently, are kind of the state law wonks here at Troutman. I mean, they handle all the state stuff. So I'll ask them if they want to put it together. Sure, we can put one of those out. But honestly, I know CCC's got great resources at the state level. Our federal, so you guys know, we do the year-end TCPA review. And in fact, our 2025 annual edition is available. If anybody doesn't have it, shoot me an email. I give it to you. It's totally free, no strings attached. I do the TCPA one every year because nobody does anything like it, right? I break down 800 cases every year and put it together in like a nice little review so that you know what's happening right now. But I don't do the state law stuff. Again, there's only so much my little brain can handle. And so I just focus on the federal stuff. But I'll talk to Pooja and Angelica. Maybe they'll put that together. We'll see.
Okay. There's a lot about Texas here. I'll do another Texas. If the tool has the ability to do a recorded voicemail drop, but you've got it turned off completely across your entire account, does that still count as having the ability under Texas law?
Yeah, see, so you get into the really great questions of capacity, right? What does it mean to have the capacity? Is it, the present configured capacity? Is it the theoretical capacity? Like, what is it? Don't know, right? That's just the truth. The Texas law is not developed on this point. Obviously, you're better served having it turned off completely. If I was your lawyer, I would defend that, and I would tell you probably have a pretty good chance of winning, but not 100% chance of winning, right? If that system has that ability, you're going to have to fight that. That's just a fight that you're going to have if they decide to sue you. Now, mercifully, the good news, right, for anyone communicating via the SMS channel is those lawsuits are just kind of out of vogue right now. Now, the DNC SMS and the, you kept texting me after I told you to stop, those are very in vogue. But just a straight, like, you used an auto dialer to text me, you're not seeing very many of those cases. Now, people will try to create some case law down in Texas. So you're going to see a smattering of these coming out here very shortly. So you do have to be aware of Texas and take it seriously. And Pooja might disagree, I'm not expecting necessarily an avalanche of those cases immediately. I think their plaintiffs are going to test the waters and try to develop some of that case law on exactly that issue. For instance, right? My system has the ability, but it's off. I don't use it. What result? We're going to have to see what the Texas courts have to say about it. Theoretically, the Texas courts should be conservative, but if you guys follow TCPA world, it's conservative, liberal, it don't matter. When it comes to the TCPA, when it comes to quote unquote robocalls, right? everyone is against them at the judicial level, and it takes a very convincing young attorney, maybe one with a good hat and black t-shirt and facial hair, to help them to understand why you can't just paint everyone with such a broad brush. So we'll just have to see how it develops.
All right. Does Texas SB 140 exempt political calls?
To my knowledge, it does not. If anybody
Yeah.
has information to the contrary, let me know.
Okay. Yeah, let's see. Let me find one more here. Do I need a mini TCPA policy? I want to contribute to that as well. Let me go first on this, Eric.
Yeah.
Let's talk about this term mini TCPA. There are so many various state regulations, and TCPA is so broad, has so many components to it. I just want us to be careful that we're not labeling mini TCPA because there's too much involved for a state to have a mini TCPA. It may have TCPA as far as dialing technology, 3 calls in a day. Those components of TCPA, that's many, but there's so many TCPA regulations, calling times, you know, pre-recorded calls, things that we talked about. So do you need one? I would say you need something like our compliance guide. You need to know what all the various state regulations are, not just one state's mini TCPA.
Yeah. So at the federal level, you're required to have a DNC policy. The law requires you to. So therefore you must. At the state level, and again, Pooja and Gallica, check me if I'm wrong. I'm not aware of any state that requires you to have a DNC policy for their state. If there is one, we need to do a blog on that because that'd be really interesting news. So you're not required to have one. So the question is it a good idea to have one? I would say the answer is yes, but only if, now we got an asterisk, only if you can keep that thing updated, right? Because the problem with any policy is that if you have it, the second that it's incomplete, non-comprehensive, or wrong, you're in worse shape having that policy than if you had no policy written down at all, right? Now, your institutional policy, enterprise level, whatever it is, should always be follow all law with respect to any outreach campaign that we run. This includes, but is not limited to, the TCPA and all state corollaries, right? Boom. That's your policy, right? But when you start getting more granular and say, for instance, in Texas, we're going to do X, in Wisconsin, we're going to do Y, that's when you start kind of running this risk of, are we being over inclusive? Are we just missing something? For instance, at the federal level, we know that the rule went from 30 days, right, to honor a DNC to now 10 days. Have you fixed
Mhm.
your policy? Because if you haven't, guess what?
Right.
You're probably violating federal law right now, even if you're abiding the 10 days, just because your policy doesn't say 10 days and the law requires you to do that, right? You don't want to have a policy if you can't keep it up to date. You don't want to have a policy if it's inaccurate or wrong. So, to me, if you're a heavily regulated institution, if you're very focused on a specific state, if you've got, sub units where you've really got to keep these guys in line and make sure that they've got something granular to follow or they won't, yes, then you should have that mini TCPA policy. But if what I just said doesn't apply to you, you're probably better served just keeping that federal policy and like an overarching policy statement of we will comply with all laws
Mhm.
and not trying to, micro procedure a mini TCPA across 50 states that's constantly shifting and moving because it's probably not going to be up to date.
And it's considered an agreement. Once you write a policy,
Yeah, got to follow that sucker. That's right.
yeah. So, all right, Eric, thank you. We're
Yeah,
at
thanks
the
for putting this
end.
together. It was a lot of fun. It's a rarely discussed topic, at least in my world. So I'm glad that we
Yes,
got to stretch some different muscles today. It's good to chat with you.
yes, you too. And I
Bye,
hope we
everyone.
helped everyone. Thank you. Bye-bye.